Good afternoon. I'm Bethany Pike, and I'm an attorney with the Elrod firm, and we do exclusively estate planning and elder law. And my practice is really on the estate planning side, so I do trust, wills, power of attorney documents, and then I also help with probate and guardianship work as well. Also, I love questions, so if as we're going through this you have a question, just jump in there. You're not interrupting me. That's completely fine. I like that. And then also, I've got my card, so if y'all think of something after today, feel free to call me, email me. You know, this is what I do. This is what I love to do. So you're not bothering me. And so if you think of questions after today, just let me know. All right. So today I'm going to talk about two main topics. So the first will be guardianship, and then I'll move into more like about supplemental needs trust. So what I'm going to cover is that, so first we'll talk about getting authority to act for your child, and then we'll move into more preserving assets and making sure they don't get kicked off of benefits, so more the financial side. So as far as getting authority to act for your child, that's where the guardianship conversation comes into play. And what guardianship is it's a court process where a judge declares someone to be incapacitated and then names someone to act as their guardian so that they have legal authority to act for them. And so if your child's still a minor, so under the age of 18, you may not have to get guardianship because your authority as their parent can usually help you. You know, you can sign them for medical care and into school and all those types of things. So it might be that that's completely sufficient as long as they're under the age of 18. The time where I see where minors do need guardianship is if their disability was maybe caused by an accident or the negligence of someone else and they're receiving settlement money. Then you have to become their court guardian to accept that money. But other than that, usually when they're minors and their parents are still living, then you don't usually have to look into guardianship. So, but when they turn 18, or around the time when they start to turn 18 is when parents get really nervous and they start calling me and they say, you know, we need to start looking into guardianship because I'm afraid, you know, they're so impressionable and that somebody's going to take advantage of them, make them enter into contracts that they don't understand. And so I really need to get court authority so that no one can take advantage of them and that I'm still acting as their parent. And so that's usually when people start looking into it. Another time where it comes up is where you know you need to look into it is that somebody tells you need guardianship. So I've had it where people, they're moving them into like some specific housing arrangement and they said, well, we can't do this unless you become their guardian. So if somebody tells you to look into guardianship, that's a good time to look into it. And then also, if your child is a minor, then you do want to think about who you would want to serve as their caregiver if something were to happen to you. So you would nominate someone to serve as their guardian. And so you typically do that through a last will and testament. And so this can be one of the hardest decisions for any parent to make, just because no one's you, no one can take your place, but it's something people don't want to have to think about, so they put it off and don't do it, but it is really, really important. So, you know, sit down, make those types of decisions, get it in writing if you know who you want that person to be. And then as a practical matter, I would say start having conversations with whoever that person or those people are now so that they know, you know, what you're thinking about and that you're thinking about nominating them to serve in that role, kind of what that would entail for them. And then also, you know, make good notes about, you know, what your child needs as far as their caregiving, you know, what their regular routine is, how to best give them medication. So little details that can make a huge difference to your child and also to the person who is looking after them. So, you know, that's not something that's a legal document, that's just something that you could prepare and update regularly that would be really nice for everybody involved if something were to happen to you. So that's really important. So if your child is an adult, so they're over the age of 18, and you may be able to get power of attorney for them and not have to get guardianship. So power of attorney is where you appoint an agent to act for you while you're living. And so it's similar to guardianship because you can still act for their healthcare decisions and financial decisions, so it can be really nice, but there's no judge involved. So they sign it, it's notarized, it's effective. You don't have to go get court permission to act or anything like that. So that can be a really nice option. But one thing is that you have to have mental capacity to set up those types of documents. So you have to be over 18, but you also have to have capacity. And so, and disability and capacity are two different things. So just because someone is disabled doesn't mean they lack the legal capacity to sign a document. So they have to understand who they are, who you are, that they want you to manage things for them. And so, it's not that they have to understand every intricacy of every word of the document, but they do have to have a general understanding of that. And if they do, then you could look into into power of attorney, and that's quicker, easier process. One thing I will mention about power of attorney versus guardianship is that the power of attorney can't go against the wishes of the person who set it up. So if your child appointed you as their power of attorney, and then you thought, okay, I really need to keep you in this hospital or in this facility or whatever it is, you can't go against their wishes. So if they say, I want to go home, and the hospital says, you're 19 years old, you can make your own decisions, they get to go home. So that's another time where you might have to look into guardianship, even if you have power of attorney or even if they could sign power of attorney, because you can't go against the power of attorney. As power of attorney, you can't go against the person's wishes. So, then, any questions so far on the guardianship, power of attorney? I feel like I'm talking a lot. Yes?
Power of attorney, so, like, for example, my son might be vulnerable in some settings, but he can also, I think, live independently, or at least semi-independently. Yeah. And I want him to have the right to vote. I want him to have certain legal rights.
Yeah.
And so maybe power of attorney is something we should look into.
Yes, the only thing is that a power of attorney, if you are concerned if he's vulnerable to somebody, like, he can still act for himself if he's power of attorney, so that he can still sign contracts and they'd still be things like that.
But I'd be able to go in, like power of attorney, I'd be able to go into doctor's appointments.
Yes.
And all
Yes.
that, which he would let me go in
Yeah.
and out, but that way I wouldn't have to each time I am trying to communicate with somebody medical or something like that.
Yes, absolutely. So you can take care of banking, real estate, taxes, insurance, all of that through power of attorney. Make healthcare decisions if he couldn't make one for himself.
So like, my son and I, we don't always agree.
Mm-hmm.
And if he decides he's done with me being his power of attorney and he likes his new girlfriend's mom, he can make her
Yes.
power of attorney.
That's exactly right.
And
That's exactly
there's nothing
right.
I can do about it.
That's exactly right.
Okay.
Yes. So, yes.
You mentioned to include in the will for a transfer of guardianship.
Mm-hmm.
Is it that simple, or is there, once you have guardianship, you can transfer it to whoever you want?
So the will is where you nominate someone to serve as the guardian. So nothing automatically happens if you pass away. So if you have not been named as a guardian over your other child and you pass away, then someone would take your last will and testament to the judge in the guardianship case, and they would say, Bob wanted me to be the guardian, here's where they nominated me. And you don't want it to be where somebody automatically has authority, because what if they're no longer a good choice? And so the judge wants to see them. They want to, make sure that they are over 18.
There's still a process.
There's still a process,
But
yes.
that helps.
It does help. It makes sure that your wishes are carried out, that the person you want to, because sometimes there's a dispute about who it should be. So if you said, I really want my sister to be it, and then, your mom says, well, it should be me, well, then the judge says, well, no, they really wanted it to be the sister. So it can be really helpful, yes.
How long is the process? Like if somebody, like my son is 16 and he will be 18. So is this process takes a month or 2 months, or does it take a long time too, so that we prepare, when we start thinking about it to the time?
Like at what age? At what age should you
Yeah,
start preparing?
what age,
Yeah.
if you don't have other restrictions, but at what age should you start so that it's done before 18 and something?
Yeah, so guardianship can be put in place really quickly if it's an emergency. So, you can have a judge sign an order the day of if it's an emergency situation, where, like I've had it where somebody needed to be admitted to the hospital or something like that. So it can happen real quick, but the normal process usually takes around a month, because what happens with a guardianship, if it's uncontested and everything goes smoothly and everything, how it works is that you get the petition prepared. So I would guess maybe 2 months would be a safe probably bet to get it all done. But the attorney will prepare the petition, and then there'll be a doctor affidavit that has to be completed that says the need for the guardianship to establish it. So you file your petition, and then you have to set a hearing, and it has to be they have to have at least 20 days notice of that hearing. So then I usually set it like 25, 30 days out. And then you have to serve the person with documents to give them notice of the hearing in case they do want to show up and contest it. And I've had people that are like, they can't communicate, and what you stop to say that the process server handed them the paper. So you serve them with the notice, and and then they're of course welcome to come to the hearing if they want to. Some people like to bring them just because, for one, they don't have another caregiver, they have to come with them, or that they just want them to kind of know what the process is and to be involved in it. Or most judges don't make them be there as long as you show that you gave them notice of it. So then you show up to the hearing, and if it's all uncontested, the whole hearing could last usually 5 minutes, because you just, you call the person to the stand and you say, are you over the age of 18, never been convicted of a felony, briefly why the guardianship's needed, and that's usually all the judge requires, and then they sign the order, and then it's in place. So it's really not that, it's not fun to show up in court, but it's really not that overwhelming of a process if it's uncontested. So if nobody's fighting it, then it really is a pretty quick thing to get in place. It's just that waiting period you can't shorten, that 20-day notice. Yeah.
And then the 20-day notice, but is it hard to get on the judge's docket? I mean, is that sometimes an issue?
It depends on the judge and the court, because
so does that mean like whether you're in Little Rock or if you're in Benton or, okay.
and which judge in that county.
Okay.
So, because they all have different dockets. I've never had a problem with the guardianship because they're really short hearings usually, because if it's uncontested, so they can usually squeeze them in. So I usually don't have an issue with that, because it's not like you're requesting a whole day trial or something like that. So luckily I haven't had that be an issue where it took forever to get the hearing set. So that's usually not too bad, luckily. And so,
I
yeah.
have a question about power of attorney.
Sure.
So I'm trying to get this in my head.
Yeah.
You're saying that the person with the disability says, I want this person to be my power of attorney?
Right. Or your agent.
They
Their
can.
agent.
They can.
Mhm.
I'm just trying to think, like, I don't think my child would even understand what the heck you're talking about. Like, what in the heck is a power of attorney for him to say,
Yeah.
I want my mom to be.
Yeah, and
So I'm just
he may
like,
not
how
have-
does this work?
And he may not have the capacity to sign the document. If he understood, I know you're my mom, I know that I have a bank account, if he does have a bank account, just kind of a general idea of what they have, and then I want you to help me manage things. It's lower than some other types of, the threshold for the capacity for a power of attorney is lower than if it was some intricate, I'm giving all my estate away type plan, because I understand that I just want my mom to help me, and there's a fiduciary duty where you have to act on his best interest and things like that.
Does that go through a judge? Like, you have to appear in a court?
No.
It's just a document that
Yes.
the
Signed with the attorney.
like my son would sign and say, I want my mom to be the power.
Like, just signed with your attorney.
Yes.
And if the child cannot sign, like in case of this, if like child is nonverbal and child does not have capacity to sign, so in that case is what's a thumb impression, or what is that, how does that work?
So as long as they can communicate enough that the attorney understands that they understand. So I mean, if it's just that they physically can't sign, then there is a statute that allows I can sign as the attorney on their behalf and sign a statement that says they directed me to sign on their behalf. But it would just be because they can't move their hand, but they understand
But
each
they have
other.
to have capacity.
They have to have capacity.
They have to understand.
They have to understand. So yes.
And they wouldn't have to know what a power of attorney was, but they could understand, I want you to help me buy groceries, I want you to help me pay my bills, I want you to help me get my, Game Boy or whatever, I don't know what
Right.
things are anymore, but.
Right, yeah,
But,
yeah,
right, I mean,
yeah,
that
exactly.
would be the situation, and then whether they know how to write or not, you could say, cause there are people that don't know how to write now,
Right.
that have no issues, and
Yeah.
just write with an X or whatever,
Yeah,
right?
yeah. But if they really don't understand it at all, like, I mean, you need to ask some questions about it, it's usually, not that it's clear, but I mean, like, if they don't understand, then for your own protection, you'd want to go the guardianship route, so.
Is there any problem or like disadvantage to get the guardianship earlier than 18?
I don't think so. There's nothing that would prevent you from getting it before they were 18. And some people like to do that, so there's no gap time between when they're 17 and when they're 18. So if you wanted to get it a little early, and I've had clients that do that just to make sure that it's in place, you can do that.
What is it usually, the court fees? What are the court fees usually run for that?
There's like a $165 filing fee, and then if it's an e-file court, that's like $180 because they charge an electronic fee. So it's usually around $200.
$200, okay.
And then there's the process server fee, which is usually around $60. So those are usually the court fees, or I guess the expenses involved with it.
Okay.
Any other questions before I move on?
Um,
Yeah.
I know that I hear people ask a lot, or are afraid that they have to have guardianship before their child turns 18.
Mhm.
What are some disadvantages of waiting until the child is already 18 before you move to have get guardianship?
I guess one disadvantage would be that if somebody did convince them to sign a contract before they turned 18, then it's a whole lot harder to go back and say that contract's not valid because they didn't have capacity, as opposed to if a judge had already declared them to be incapacitated. Or if you needed to make a decision and you didn't have that authority, well, then you'd be scrounging around real quick trying to get it, as opposed to if it was already in place, you wouldn't have to worry about it. So.
Nothing, beyond that, no legal ramifications for waiting.
No.
I can tell you a story that I got a phone call on the Arkansas Down Syndrome Association line that the child was hard to understand on the phone, was upset over a friend having died, called the police while the mother was sound asleep. They picked him up because they thought he was going to harm himself and admitted him to the Hot Springs Hospital, and she could not have access to him because she did not have guardianship. She called me panicked. And it took a good 24 hours to work, because it was on the weekend, to work with hospital administration and the place where she got services for him. But she didn't realize he was already 18, he had just graduated high school, and she didn't have it. I mean, who would have thought that? Who would have thought she wouldn't have woken up when they came to her house to get him? But, so, I mean, it's a crazy thing, but it's a crazy world. So there are some circumstances. As a nurse, I've seen some
Yeah,
healthcare
no, I bet.
circumstances like that.
Yeah.
That's good. Thank you.
All right. Any other questions before we move on to finances? All right. So we talked about making sure somebody has authority to act for the child, and then now we'll move on to the financial side of it and making sure that receiving benefits doesn't kick them off, or receiving inheritance doesn't kick them off of their benefits, and also making sure someone's in place to manage finances for them. And so earlier we talked about the will, and that's a good place to nominate a guardian. But a last will and testament in general is your written instruction for what you want to happen if you were to pass away. And so you're going to specify who you want to wrap up your affairs, who you want to receive your assets, and you can also nominate the guardian. And you can have simple wills, you can have more complex wills. But one thing that you want to keep in mind is that how you leave assets to people can have a very big impact. And so if you leave assets to someone directly, it becomes theirs. So if they are on government assistance that has an asset restriction and you pass away, and so you give them $100,000 or $3,000, they're over $2,000 now, and they're going to get cut off until they get back under that limit. So you have to be really careful with how you do that. And so the most common way to prevent that from happening is setting up a supplemental needs trust or a special needs trust. And so I'll kind of explain that a trust in general is an entity that you set up to hold assets. And so there are different roles of the trust. There's always a creator of the trust, there's always a manager of the trust, and then there's always a beneficiary of the trust. So if I set up a trust, then I'll be the grantor of it, and then if I said my dad's going to manage it, then he's the trustee of it, and then it's for the benefit of my daughter, she's the beneficiary of it. So my dad would be the only one who could access the funds for my daughter, but he has to follow what the trust says as far as the guidelines for making distributions. And then the most common type of trust that we do is a revocable living trust. And so that's the one where you're in complete control of it and you can change it. It's kind of like a will where you say, here's what I want to wrap up my affairs and here's what I want to receive my assets, but it doesn't have to go through probate. And probate's this long, drawn out, expensive court process. And so a lot of families want to avoid that. So we set up a lot of revocable living trusts for people. And so, and another benefit to setting up a trust is that you can put protections for your beneficiaries. So maybe you have a child who doesn't have government assistance, but you want to put protections on how and when they can receive their inheritance. So you can say they're going to receive their funds in trust, this other person's going to manage it for them, this is how and when distribution is going to be made. So trusts are a very good estate planning tool. But then if they do have those asset restrictions, that's when you want to look into a supplemental needs trust or a special needs trust. And you can use those terms interchangeably, so it's the same thing. So basically, that's a trust that's set up to ensure that someone who's on government assistance that has an asset restriction doesn't lose those benefits by receiving assets. So that's the purpose of that type of trust. And so Then, and you know, the real reason that people set up these types of trusts is that they're worried. You know, they want to make sure that their child's taken care of. They want to make sure there's not abuse or neglect, and so they set this up and they make sure that the right people are in the right roles with enough checks and balances to make sure that their child is looked after, that they receive the best care and treatment and things like that. And so you know, the best thing is to just be proactive. Put a plan in place so that if something happened to you, you know, everything's taken care of and that they don't lose their benefits. And then I'll mention kind of the interaction between the will and the revocable trust and the supplemental needs trust. So in just about every will or revocable trust, we set up supplemental needs trust provisions in those documents. And it's kind of a safety net to say that if anyone's ever going to receive an asset from this will or from this trust, hold it, you know, funnel it through that supplemental needs trust. Just because no one knows, you know, down the road, somebody could be on benefits and you don't know when you set up your plan if they will or they won't. So it's really nice to have those protections. And then some people like to have it set up as a standalone trust, so a separate supplemental needs trust. So they may have their own plan and then they'll set up this separate one for their kids. And so the nice thing about having a standalone one is that multiple people can contribute to that trust. So if you have parents who want to provide for your child when they pass away, or maybe it's a divorced couple and you both want to provide for the child if you both pass away. So there's different pros and cons of having it inside another plan and having it as a separate one. But definitely it's important to have it in some way or another so that they don't get kicked off of those benefits. And then another thing, you know, this is a very restrictive trust, you know, to make the government happy so that they don't lose their benefits. It has to be written very restrictive. And you want to make sure that you appoint the right person to serve as the trustee of that trust. So you do want to put a lot of thought into that about who would be a good manager of it. And if you don't have a great person who would be a good option, then you could always think about like a corporate trustee, like a bank trust department or something like that. So there are places out there that can serve in that role if you don't have a good choice. Yes. No, you're perfect.
So the special need trust, like if I understand correctly, you said there should be a trustee and there is a creator. Can a creator be a trustee? Like suppose if we create a special need trust for a child who's not able to make decisions or so, but we want to help and we don't have we have a trustee, but after 18 or can a person who has created can still help from that trust to help the child, or it is only one person who is a trustee can manage the trust. You understand? So like if you as a parent created a special need trust for the financial and other reasons, but who manages? You said that the person who is a manager of the trust would be able to take the funds, but the creator of the trust would not be able to help the child. Is that?
You can. So the reason that doesn't come up too often is that usually parents have it set up where that trust isn't going to be funded until they die. So that it would be basically if you wanted to spend your own money on your kids, you wouldn't put it through this trust and then you just spend money out of your bank account and spend on whatever they need. So usually if you set up the trust, the thought is that it wouldn't be funded or that assets wouldn't go into it until you pass away, because that's really where it will go into their names. And so you don't want it to go into their names as an individual. You want it to go through this trust. Does that make sense? Oh, sorry.
Can you have if you say in your will, I want this person to be the guardian of my child with special needs, and can that same person also be the trustee of the special needs trust?
Yeah, so they're just different roles. So yeah, the same person could be the guardian as the trustee. Some people like to do kind of a checks and balances, so they'll have, you know, one person be the trustee over the finances and somebody over the physical care of the child. So, but however, it could be the same person or you can do separate people, whatever works best for your family dynamics.
How does it differ from the able account, a special need trust and able account? Like, what is, somebody had mentioned before in one of the conferences, so I'm just trying to.
So an able account, I'm definitely not an expert on this, but I will tell you what I do know about it. It's a financial product. It's a type of bank account that's set up. And so they both work well together. So it's nice for somebody to have an able account, but then it's nice to have this trust, because you wouldn't leave your house to an able checking account. You know, you wouldn't say, if I die, this house passes through that. And usually the disabled person is the owner of that account. So it's nice because it gives them, some autonomy, because with the trust, they don't have any access to the trust. The trustee's the only person who does. So if they have this ABLE account, then that's some money they can manage. I mean, there are caps on how much can be in there, but they're the ones who get to put their money in it, and they can use it on things. And they're similar in that it prevents government or losing government benefits, but it's a different type of thing. So usually people have an interplay of both of those types of things. So that's a good question that comes up a lot.
So they can be used for their own care later on by the disabled person or their guardian and not, it's not like after the death of the parent or something like as a special need.
Right. And also if it's hope I'm not getting too deep into this, but if it's a supplemental needs trust that somebody else set, so if you're the parent and you set up this trust for your kids, you don't have to have a state payback provision, which would say that if the child dies, then you say where the money goes. If it's an ABLE account, there has to be a state payback provision, which says whatever's left in here gets paid back to the state for whatever they paid for. If the person who is, this is I know way too much information, but if the person who is disabled sets up a first-party supplemental needs trust, there has to be a state payback provision. So that's why I say it's really important for y'all to set up the trust and then for your assets to go into it, because then you don't have to have things like state payback provision. So. Sorry. I am totally nerding out, yes.
What is the usual, the base amount usually that y'all ask to be able to, when setting up a special needs trust? Do they have to have a certain amount in order to start one, or it can be any amount?
Yeah, it can
It's
be.
I have family members and they keep wanting to open up a savings account for my son and he's on
Yeah.
disability, so I'm like, no, don't you do
Yeah,
that.
yeah.
But it's small amounts, they want to put in there
Yeah.
for his birthday and
Oh,
Christmas
yeah.
and stuff.
No,
So I didn't know if there was a certain amount we have to start with.
No, I mean, you could start with whatever it takes to open up a checking account. I mean,
Okay.
but you could start the trust document, and we just say it was funded with $10 just to start the
Okay.
trust document. So, no, that's completely fine. You can fund it throughout. No problem with that. Question? Yes.
This is just about fees, about how much does it cost for an attorney's fees to set up a will, for a person like me. I'm a widow, I've got a child with special needs, and then a special needs trust.
Yeah.
So that when I die, there's someone to take over.
Yeah. So, I mean, the fees range, and so how we do it is that if you come in, we do a free initial consultation, and then we see everything that you might need, and then we'll give you options, and then we'll say, okay, if you want this package, it's this amount flat fee. If you want this one, it's this amount flat fee. So, I mean, if it was solely just one last will and testament, you could be on the $750 range. If it's a full-blown trust package, you might be more on the $2,000 to $3,000 range. So, kind of like that.
Just curious.
What about power of attorney?
Yeah. So usually if we do a power of attorney package for a single person or one person, it's like a $500 fee for a power of attorney package.
Thanks.
And for the guardianship, usually for the guardianship.
Yeah, usually that's usually around a $2,500 flat fee, or I guess we usually say it's a retainer, but that usually covers everything. So yeah.
Got quiet when you started
Yeah,
talking
I
about it.
know. Well, this was fun. Real fun. And then one other resource I wanted to tell y'all before I forget is that if you are interested in what this supplemental needs trust is and how it works and what the person can and can't spend, it's called specialneedsalliance.org, and they've got a handbook for a trustee of a special needs trust, and it's a really good resource for people, and I point people to that a lot if they do set up this type of trust. So so that's just on the internet. So if you
Special Needs Alliance, what?
.org. So in case that's helpful to you. Anything else? Okay. Well, I do love talking about these issues, and you can always call me, email me. I'd be happy to answer any other questions that you have. And I guess that's really everything that I had planned to cover, unless y'all do have other questions. And if
I have a question.
Okay.
Guardianship, the kid has to go on the stand. What if he's nonverbal and doesn't have the mental capacity?
Oh, the child doesn't have to be on the stand.
Okay.
No, unless they were contesting it, then the judge would let them. But I'm sorry, I should have explained. The person who has to testify is the person asking to be the guardian. So the judge, I mean, like it might last 5 minutes, just ask basic questions to make sure you're qualified under the laws of Arkansas to serve as the guardian. Yeah.
It's my understanding that you can have guardianship and still they have their right to vote as long as it's written into the guardianship papers. Do you know if that's correct?
I would imagine, and I would say that I haven't had that exact issue where somebody was taking away the right to vote, but I think that's one of those things where you have to ask for permission to take it away.
It used to be.
Oh, okay.
From what I understand, about 11 years ago, that changed.
Oh, nice.
Yes.
Sorry,
And,
nobody's ever asked me that actually, so.
that's why. And then so I've heard since then that you can have your guardianship and go back and then ask for them to have their voting status, or when you write the guardianship. I haven't asked a lawyer per se, but these are some of the moms
Yeah.
with through the University of Arkansas
Yeah.
that have said that
That's very
you have
good
to
to
ask
know.
for that up front.
Yeah.
Or go back and
Say that
petition.
one more time. I'm sorry.
That you have to go back and petition if you don't write it into the guardianship, that they retain their right to vote.
Okay.
So if you have a guardianship, if your child has a guardianship, you're not eligible to vote?
Depending on when it was written. I forget how old is Nicholas.
He's 24, he's had a guardianship since he was 18.
So it probably, yeah, so it may not
It may not what?
have the right to vote in there.
You-
is what
You could probably go back and
understanding of it.
petition for it, I would
Yes, and
imagine.
but they were just saying, yeah, that you have, that more fees. So
Yeah.
they're trying to get people
Really
to
good
understand
at
and ask
that.
that upfront.
No, I'm glad you pointed that. Most of my guardianship cases are older, significantly older people who have dementia and who, so I guess that's why it doesn't come up, you know, because they're like in a nursing home and like that's
Right.
usually the guardianships I deal with. So, but I am glad to know that. So if it does come up, I'll ask for that on the front end. Yes.
So when we did our guardianship, they were asking about who has to talk to the judge. The judge did ask my son lots of questions about it. So the child, is, questioned about what they think about it. I had a friend who did the same thing in Mercer and said, no, I don't want my parents to be my guardian, and just
Oh,
went through the whole
wow.
thing. We're like, what?
Well, my friend just went through that, and the judge didn't call her son at all.
They called mine,
Did they?
and also I had made special arrangements that they could not serve my daughter papers without being at my mother's house
Mhm.
or my
Somehow
house.
that, yeah.
Yes.
They had to notify me before they, which I had no objection them serving,
Right.
but our big thing, do not take anything from strangers.
Yes.
Do not answer anything from
Mhm.
strangers. And they said it could be at school they give it to,
Yeah.
or at her work.
No.
So you can ask them to do, yeah, it costs you a little more, but it's worth it to me.
Yeah, no, I always make, because it's always better to have people there who can, make sure that nothing, they don't get freaked out and things like that. So you can definitely set up when and how the process server gives them the paper. So that's a good point, very good point.
Okay, so one last question. I have a will
Okay.
that was written by an attorney, and it talks in there about how a special needs trust will be set up upon my death.
Yeah.
So if I have that will, would that avoid going to probate?
No. So a will does not avoid a probate court process. So the good news is if you have that will and there's supplemental needs trust in it, then your child wouldn't get kicked off of their benefits. It's just that they would have to go through probate, because how a will works is that you don't change assets into the name of a will. The will just says anything that's in my name when I pass away, this is what I want to happen with it. So whoever is your representative would, if you pass away and your home was still in your name and your bank accounts were still in your name, they would take the will to probate court and they would say, okay, we need to probate this, and they'd go through the whole process. And then at the end of that whole process, which usually takes around 8 to 9 months if everything goes smoothly, then they would funnel all that money through that supplemental needs trust. So the trust, if you do a trust and put your assets into that, it avoids probate because it's an entity that still exists if you pass away. So if you put your assets into this trust, then you would say, if I'm no longer here, this person has authority to act. So they don't have to go get a judge to say you have authority to act because it's already set up in this little entity. So that's kind of like why the will won't avoid probate, because it's just an instruction.
And then once you get let's say I set up a revocable living trust, and once that's set up, then I need to move all my assets into that name of that revocable living trust, like my house, my bank accounts, all that stuff needs to be
It's
changed?
it's important, you have to fund the trust. And so we typically will do deeds when we do the trust to transfer any real estate in there. And then we'll do a letter that says, in most financial accounts, you can just put it as a death beneficiary. So you don't have to get new checks issued or anything like that. But you do have to go to the financial institution and say, will you make my trust the pay on death beneficiary so that if something happened to you, it funnels through the trust.
And the life insurance policy.
And the life insurance policies, yes,
So
absolutely.
that's part of what you do as an attorney is take care of all of that? Is that?
So we do as much as we can. So real estate I can do, and then I'll do a letter. And if you work with a financial advisor, I'll say, you know, you can get me in contact with them, and I'll send them whatever they need. But if I call up State Farm and say, hey, I need a change of beneficiary form, they're going to say, hey, you don't have an account here, so I'm not talking to you. So, but we'll give you as many. And then I usually tell people, if you can get a beneficiary form, bring it back to my office, and I can fill it out for you. So that's usually. So we try to hold hands as much as we possibly can through that process, as much as they'll let us. Which is good. You don't want them changing things because I say so. All right. Anything else?
Thank you so
Yeah.
much.
Yeah.
Thank you.